All right, the regular meeting of the Civil Service Commission for February 5th, 2025 will now come to order. Welcome in-person and online attendees. If you want to provide oral comments on any of the agenda items, please be sure to follow the instructions on the first page of the agenda. If you're attending the meeting in person and you would like to pull an agenda item for discussion, when asked, please stand and identify yourself by your name or number, and we will return to your item after the consent agenda is approved. Attendees joining this meeting using the Zoom application will alert commission staff of your intention to speak about an agenda item by using the Q&A function at the bottom of the screen. Please include your name, telephone number, or other identifying feature you selected when logging in and the agenda item you want to speak about. Attendees who dialed in today's meeting, please press *9 on your telephone to raise your hand to alert commission staff of your intention to speak about an agenda item. When called upon to speak, please mute yourself using *6 on your telephone. We will now commence with the order of business. Will the Commission Secretary please take the roll?
Commissioner Coleman,
Present.
Commissioner Fletcher,
Present.
Commissioner Johnson,
Present.
Commissioner Rodriguez Kennedy.
Present. The second item of business is the approval of the minutes. May I have a motion to approve the minutes of the regular meeting of January 15th, 2025?
Commissioner Johnson moves to approve the minutes.
Is there a second?
Commissioner Coleman seconds.
Any discussion? Seeing no discussion, will the Commission Secretary please record the votes?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy.
Aye, that passes unanimously. The next item is letter C, non-agenda public comment. Members of the public may address any matter relating to the Civil Service Commission other than items that are on today's agenda. The total amount of time for public comment will be limited to not more than 2 minutes unless the Commission President agrees to extend the time. Do any of the attendees want to make a public comment about any matter relating to the Civil Service Commission, but that is not on today's agenda? If so, and you've joined the meeting using Zoom, please use the Q&A function on the bottom of your screen to inform Commission staff. If you dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon for you to speak, please unmute yourself using *6 on your telephone. We will need to wait a minute in the event somebody wants to make a comment and is attempting to alert staff now. Will the executive officer please start a timer? Yes.
Commissioners, 1 minute has passed and we've received no request to make a public comment.
Thank you. Hearing none, we will now move on to agenda item D, which is agenda item discussion. Do any attendees want to pull an agenda item for discussion? If you're attending this meeting in person and you would like to pull an agenda item for discussion, please stand and identify yourself by name or number, and we will return to your item after the consent agenda is approved. If you're speaking for an appellant or complainant, please use their assigned number. If you've joined the meeting using Zoom, please use the Q&A function at the bottom of your screen to inform Commission staff of the agenda item you wish to speak about. If you've dialed into today's meeting, you may press *9 on your telephone to raise your hand to alert Commission staff. When called upon, you may speak. When called upon to speak, please unmute yourself using *6 on your telephone. We will need to wait a minute in the event that someone wants to pull an agenda item and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
So we will be pulling item 4 from the consent agenda. Thank you.
Commissioners, 1 minute has passed and we've received one request to pull item number 4 for discussion.
All right, item number 4 is pulled. Formation of, we'll now move to item E, which is formation of the consent agenda. Will the Commission Secretary announce the items forming the consent agenda?
Commissioners, items available for vote on consent is item 3 and 4 have been automatically pulled. Other agenda items have been discussed and can be voted on the consent agenda is item 1, item 2, and item 5.
May I have a motion to approve the consent agenda as the consent agenda?
Commissioner Coleman votes to approve.
That's a motion. Is there a second?
Commissioner Fletcher seconds.
Is there any discussion? Commission Secretary, please record Commissioner votes.
Commissioner Coleman. Commissioner Fletcher.
Aye.
Commissioner Johnson.
Aye.
Commissioner Rodriguez Kennedy.
Aye. That passes unanimously. We'll now move to item F, which is discussion items. The first item is agenda item 3, which is Commissioner Johnson's report on a disciplinary hearing. Do any of the attendees want to speak about this agenda item? If so, and you joined using Zoom, please use the Q&A function at the bottom of your screen to alert Commission staff. If you dialed into today's meeting, please press *9 to raise your hand and alert Commission staff. We will wait a minute in the event that somebody wants to speak about this agenda item and is attempting to alert staff now. Will the executive officer please start a timer?
Yes.
No, it's the next one. You're good.
Commissioners, 1 minute has passed and we've received no request to speak about this agenda item.
All right, hearing none, we'll please, Commissioner Johnson, if you could please proceed with your report.
Sure, thank you. Appellant number 2024-044P, otherwise known as employee, appealed an order of termination and charges removing him from the position of deputy sheriff in the Sheriff's Department, also known as the department. The commission appointed me, Commissioner Melissa Johnson, to hear the appeal and submit findings, conclusions, and recommendations to the Civil Service Commission. Thereafter, a hearing was held on December 12th and 13th, 2024. The causes of discipline were 3 charges of failure of good behavior, 1 charge of intemperance, conduct unbecoming, dishonesty, and acts incompatible and or inimical to public service. Prior to the start of the hearing, the employee raised an objection and moved to dismiss the order of termination on the argument that the department's notice of proposed disciplinary action was issued beyond the 1-year statute of limitations under the Public Safety Officer's Procedural Bill of Rights. This motion is denied. Near the end of the hearing, the employee raised his second objection to the discipline on the basis that the pre-disciplinary procedures followed by the department, as mandated by Skelly versus the State Personnel Board, otherwise known as Skelly, were insufficient to provide the employee with the requisite due process under Skelly. The employee's motion to dismiss the action based on the lack of procedural due process is denied. The factual findings are this. In the hearing, the employee asserted his Fifth Amendment right against self-incrimination. The employee and his girlfriend were in a romantic relationship between December 2020 and ending in July 30th, 2022. The evidence supports a finding that the events that the girlfriend complained about have a common feature: the employee's off-duty alcohol consumption. The girlfriend's statement in the Internal Affairs IA interview with the lieutenant consistently reflect that the employee showed up at her apartment or at her place of work in a state of inebriation, while the employee, during his IA interview, denied that his lack of recollection had anything to do with his intoxication at the time. Discussions exchanged between him and his girlfriend consistently reflect and contemporaneously that he couldn't recall what happened even the evening before. Yet his excuse at the time of his IA interview by the lieutenant was that it was too long ago. Fortunately, there are text messages. In none of these does the employee emphatically deny or even deny the complaints or recitation of the events occurring less than 24 hours prior to each response to the text, including his girlfriend's communication of harm caused by physical violence. There is evasiveness, but when pressed by the girlfriend, employee provides a tacit admission and an apology. Importantly, not once did the employee attempt to correct the messages in his responses, nor did he consider ending their relationship because he believed, at the time, that the girlfriend's messages were fabrication and lies. The evidence presented by the department supports a finding that on September 21, 2021, after consuming alcohol, the employee left the girlfriend's apartment and came back to the apartment and, finding it secured by a chain lock, broke the device by forcing the door open, ripping the attached from the base from the molding at the door jamb. The employee thereafter ransacked the girlfriend's bedroom, strewing clothing and personal belongings around her room. The evidence presented by the department supports a finding that on January 2, 2022, following the consumption of alcohol, the employee called the girlfriend, asking for her to give him a ride home. The girlfriend complied, and while at the employee's residence, the two of them engaged in an argument, the result of which was the employee became physical with her by grabbing her shoulders with both hands, pushing her against the wall, and then shoved or struck her face 2 or 3 times with his open right hand. The evidence presented by the department presents a finding that on May 28, 2022, the employee communicated with a female friend through direct messaging on her Instagram account, messaging, quote, "Hey hottie, let's do coke," end quote, meaning cocaine. The friend's response included, quote, "I do not do cocaine," to which the employee responded, quote, "Well, we do, LOL," end quote. This exchange concerned the friend that a deputy sheriff would send such a message. The evidence presented by the department supports a finding that on June 20, 2022, around 2:00 a.m., the employee accessed the girlfriend's apartment unannounced and accused her of cheating on him with his male friend. The girlfriend told him that she was dog-sitting for the male friend. Since he was having his bachelor party the next day, she had offered to watch his dog. The verbal argument led to a physical altercation, with the employee shoving her head into the headboard of her bed approximately 2 or 3 times. The evidence presented by the department supports a finding that around 10:30 p.m. on July 4, 2022, after consuming alcohol at a separate event, the employee visited the girlfriend, who was working at a bar, to get a ride home from her. While together at her workplace, he called her an idiot and a stupid effing bitch. And he actually did say the word in front of others, particularly in front of the coworker's girlfriend, whom she had just met that night. The employee was slurring his words and could barely stand up. Based on her experience of working in bars, the girlfriend could recognize the signs of a patron who was extremely intoxicated, and the employee exhibited very clear signs of intoxication. The evidence further supports a finding that the girlfriend was embarrassed by the employee's conduct. For example, showing up at her work intoxicated and belittling her, telling her in front of coworkers about girls, naked girls, and that's a quote, at the event he had just come from. Finally, having agreed to give him a ride home, the girlfriend was subjected to more vitriol from the employee when he began berating her, calling her a slut and a whore. When they arrived at his home, the employee refused to get out of the car. Frustrated and upset and crying, the girlfriend just wanted him to get out of her car. After leaving the employee's home and arriving at her apartment, the employee later showed up at her residence and spent the night at her apartment. He left early in the morning without any communication from the girlfriend about his conduct until the exchange of text messages about his misbehavior the night before. Conclusions. The employee is guilty of failure of good behavior where on September 21, 2021, at approximately 3:00 a.m., he forcefully broke the security device on the entry door to the girlfriend's apartment, thereby causing damage to the property. Employee is guilty of failure of good behavior where on January 2, 2022, he was involved in an argument with his girlfriend at which time he battered his girlfriend during an argument by shoving her by the shoulders and then again in the face with an open palm strike or a push. The employee is guilty of failure of good behavior where on June 20, 2022, he was involved in an argument with his girlfriend, at which time he battered his girlfriend during the argument by shoving her 2 or 3 times in the face with an open palm strike or push. The employee is guilty of intemperance where on July 4, 2022, his off-duty consumption of intoxicating beverages resulted in public intoxication, obnoxious behavior, and a domestic dispute with his girlfriend. Such conduct discredited the employee as a deputy sheriff and had the potential to erode the reputation of the San Diego County Sheriff's Department. Employee is guilty of conduct unbecoming, where on May 28, 2022, he communicated with an individual on Instagram who was aware of his status as a San Diego County Deputy Sheriff and invited her to join him in using cocaine. Such conduct, even if done in a joking manner, discredited the employee as a deputy sheriff and had the potential to erode the reputation of the San Diego County Sheriff's Department. The employee is guilty of dishonesty where on April 26, 2023, he displayed a pattern of evasiveness and deceit in responses to the Internal Affairs Investigators' administrative review. The employee's conduct during the procedure proved that he was not truthful to the fullest extent of his knowledge during the administrative review and in answering the investigators' questions. The employee is guilty of acts incompatible and or inimical with public service where his conduct is set forth in the preceding conclusions. Level of discipline. Important in this analysis is the employee's likely issue with his consumption of alcohol, even if off-duty. As pointed out by the testimony of his girlfriend and the female friend, they were concerned that somebody holding the position of deputy sheriff would participate in such off-duty activities that involve drinking to intoxication or messaging about the use of illegal drugs. I share their concerns. An employee who drinks excessively, commits battery on another person multiple times, is so publicly intoxicated that it results in obnoxious behavior and publicly berating another person, brags or jokes about using cocaine, is it dishonest and discredits or erodes the reputation of the San Diego County Sheriff's Department, should not remain employed as a deputy sheriff. Therefore, I find that the department has met its burden of proving the charges detailed in the causes of discipline and further find that the department's decision to terminate the employee is reasonable and should be affirmed. My recommendations are based on the findings and conclusions set forth above, and I hereby recommend the following decision: that the order of termination and charges be affirmed, and that the proposed decision shall become effective upon the date of approval by the San Diego County Civil Service Commission, and I so move.
Thank you, Commissioner Johnson. Do we have a second?
Commissioner Fletcher seconds.
Do we have any discussion? Seeing none, will the Commission Secretary please record the commissioner votes?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy.
Aye. Where am I? All right, so that passes unanimously. We'll now move to agenda item 4, which is Commissioner Johnson's report on a discrimination investigation. Do any of the attendees want to speak about this agenda item? If so, and you join the meeting using Zoom, please use the Q&A function on the bottom of your screen to alert Commission staff. If you dialed into today's meeting, you may press *9 to raise your hand to alert Commission staff. We will need to wait a minute in the event somebody wants to speak on the agenda item and is attempting to alert Commission staff now. Will the executive officer please start the timer?
Yes.
We're still going to wait, but we, yeah. You can sit.
Commissioners, 1 minute has passed and no other people have requested to speak about this agenda item. We do have one person present that does want to speak, and that person can sit at that table there.
Just a reminder, you have to speak right into the mic. So. Um,
2024-008.
all right, 2002 or 24008, you have 5 minutes.
Good afternoon, members of the Commission. Thank you for your time today and allowing me to present my remarks. I've been continuing to edit and refine these all the way up until now, and I apologize in advance if I trip over my words out of being nervous. My termination on February 16th, 2024 completely shattered my life and my career. I'd done everything supposedly right. I had earned my bachelor's degree, my master's degree.
Speak closer to the microphone.
Secured my dream job, successfully completed training, and received a strong midpoint performance review. Despite this, I was released during probation in what I believe was retaliation. My complaint is based on unfair treatment and procedural failures that denied me a fair chance. This commission has previously ruled on matters relevant to my case. On August 3rd, 2022 and 2022-199P, the Commission addressed a late performance appraisal from the sheriff. When Commissioner Rodriguez Kennedy asked about the harm, the Employees Council stated that it led to a lack of stable relationship with his employer. Commissioner Smith further emphasized that employees must be given a fair opportunity to respond to any deficiencies. In my case, I was never given that chance. My supervisor withheld 3 months of our weekly supervision notes, weekly supervision being a policy that HHSA requires during probation. These were presented to me all at once the week before my termination. There was no opportunity for correction, for discussion, and much of what was listed was inaccurate and left me no time to dispute it. On March 6th, in 2024, in March 6, 2024, in 2024-005, also listed as 2024-004, a senior office assistant with the Health and Human Services Agency requested that a late performance review be sealed for including matters outside of the rating period and for being late. Commissioner Rodriguez Kennedy stated that he supported sealing untimely appraisals, stating that if employees are held accountable for deadlines, managers should be too. Commissioner Johnson highlighted how late performance reviews deny employees a fair chance to improve before termination. This is exactly what happened to me. By my supervisor's own admission, the written confirmations of our discussions did not occur until the week before my termination, and again, much of what was listed was inaccurate and accused me of major issues. The letter when I was released stated that I was found unsatisfactory. I had no time to correct or dispute anything before HR was convinced to fire me, and there are substantial issues within that decision, including that I made a written request to transfer to another supervisor to avoid this after being concerned about my supervisor's actions, and was fired the same day I started with the next supervisor. Today marks day 355. I didn't deserve this. I had great relationships with families, with coworkers, resolved disputes, submitted work timely, and was praised by families directly to my supervisor and other staff. Yet, 310 days after OEC began its investigations, I learned that the witnesses I asked them to contact were never contacted and were never interviewed. I respect the OEC's mandate and their workload, but after meeting with two separate investigators, reiterating my story twice and repeating my story twice, and then learning that there was a failure to reach out to key witnesses resulted in an incomplete investigation that unfairly prejudices me through this process. When first starting as protective services workers, we're trained on the importance of collateral calls during investigations, contacting those who know a family well, even when it seems tedious and unnecessary. Yet in my case, OEC ignored my witnesses, delaying my case for nearly a year while ultimately appearing to rubber stamp the agency's decision. I trusted this process only to be failed by it. At the Commission's most recent meeting, in matter 2024-064P, Commissioner Johnson also stated, when somebody gets fired from their career
30 seconds.
and their job, it takes an emotional toll because your job is part of your identity. I don't wish to start over elsewhere. I want to return to my career and my dream job in my dream place. Over the past 355 days, I've had a lot of time to reflect on things. I'm by no means perfect, but I'm a hard worker, always trying to learn and always looking for ways to improve myself. As you know, the Commission standard for granting a hearing is probable cause. A flawed, incomplete investigation that went an extraordinary amount of time alone should meet that threshold. Momentarily, I know the agency will dispute what I'm saying, and I also believe a contested issue of fact is a reason to grant a hearing. I ask you to grant me a hearing and to give me the fair chance that I was denied and to prove I'm eligible for relief. Thank you.
Thank you. And I allowed 30 extra seconds, so I'll allow the department to do the same.
Does the department want to make any statements? No.
Then let me find my place here. Well, I think so. At this point, I'm sorry. Did you have a question? Yeah, go ahead. Do you have any questions for this witness or appellant? Any questions by the commissioners?
I don't.
No questions so far? All right, so seeing none, then we will go to Commissioner Johnson, if you'll read your report.
Or thank you. On March 6, 2024, the Commission appointed me, Commissioner Melissa Johnson, as its member to be the investigating officer in the matter of the complaint submitted by employee 2024-008, former protective services worker, which alleged discrimination based on retaliation for engaging in a protected activity by the Health and Human Services Agency. In accordance with the established rules and procedures of the Commission, the matter was concurrently referred to the Office of Ethics and Compliance, otherwise known as OEC, for investigation. The OEC concluded the discrimination investigation and reported its findings to the Commission. I have reviewed the OEC's report and have taken into account all documentation submitted in this matter. I concur with the OEC's report and have concluded that the evidence does not support a finding of probable cause that a violation of discrimination laws occurred. Civil Service Rule 6.1.4, issuance of temporary orders, states in relevant part, quote, upon the filing of a complaint, the Commission may issue such orders as are necessary to maintain the status quo, to further actions relative to the employment process in issue, or to avoid potential continuing damages, end quote. On July 25, 2024, employees submitted a request under Rule 6.1.4 requesting, quote, the Commission to make temporary orders awarding me partial continuing wages at 85% of my hourly wages at time of dismissal until the hearing is conducted, end quote. By using the term may, Rule 6.1.4 is by definition discretionary. The three scenarios for exercising its discretion are as described above and addressed as follows. First, Rule 6.1.4's remedy to protect the employee's status quo is an intent to protect the employee's status such that if no intervention occurred immediately, then status quo would be lost. In this situation, the employee has already been dismissed from his position. Second, the remedy of Rule 6.1.4, barring further actions relative to the employment process, is similarly applicable to complaints of current employees of the county. It contemplates a complaint of discrimination exercised by current employees when the Commission agrees the current employees should be protected from possible discrimination or retaliation. Third, the Commission should consider the temporary order by the Commission under 6.1.4, quote, to avoid potential continuing damage, end quote. If following a hearing, the Commission determined that a violation of the Commission Charter, Section 901 occurred, the Commission's remedy of back pay and reinstatement would be enough to make the employee whole. In this case, there is no such determination. I therefore recommend that the employee's Rule 6 discrimination complaint be denied and no hearing be conducted. 2, the employee's request for a temporary order awarding him 85% of his hourly wages until the hearing is conducted be denied. And 3, the Commission approve and file this report with a finding of no probable cause to believe that the complainant has been unlawfully discriminated against, and I so move.
Author, you can have a seat. Thank you, Commissioner Johnson. Is there a second?
Commissioner Fletcher seconds.
Okay. Discussion. So I have a question for the commissioner. Are we and we'll have to see where this goes. The request was the appellant, right? Are they appellants?
No.
Complainant. There we go. The complainant, we have different types of cases, so I'm trying to figure it out. All right. The complainant says that the protected activity was a request to be transferred to another. Was that what I heard? That the request. Actually, I'll ask you. What was your? I'm sorry. Be more clear. What was your protected activity? Actually, come back over here. I'm gonna ask you. I'm gonna have a question. Sorry about that. There's a lot of things going on. What was your accusation? What are you saying is the protected activity?
So there's several parts. So the first is, well, it's under the broad category of retaliation. There's a couple things. So, sorry, not used to speaking into my.
No worries.
So there's a couple things. Most of when this started stemmed because when my supervisor was out, and I'm trying to send.
I'm gonna need you to be what are you saying?
I'm trying to.
I don't want to hear into like the context. I want to.
Yeah.
What did you request that you were retaliated for?
So the first was because she didn't agree with decisions that were made when she was out of the office after consulting with different supervisors. Then it was giving me 3 weeks all at once or 3 months all at once while containing fully inaccurate information, or at least partially inaccurate information.
Okay.
At the end, I made a request to transfer to avoid this issue. And in the middle, I reported this to the manager out of my concerns, followed what she recommended. And then I made a request to transfer to another supervisor. That was granted, and then I was released the same day.
Okay. All right. Thank you. That's all I have for you. Was that included in the report? And would that have changed anything if it was? Okay. All right. But was it in the report?
The complaint does allege, and it was investigated, that the
What was that?
the table.
Oh, look, it broke.
Yeah, there it is. If you push that top part too hard, it falls forward.
Well, now we've learned something about the tables.
Yeah, I've done it before, just nobody noticed.
All right, carry on.
In any event, I actually, while our complainant was talking, I was trying to pull up the investigative report unsuccessfully, but had the wrong password in there. In any event, it does allege that he was informed 3 or 4 months ago that there were issues with his probation, and he had, and my understanding is that was the quote unquote protected activity.
Right.
But also part of the termination was the allegation that he had followed a worker.
Right. There's other parts of it.
Yeah, and threatened them about, if I don't pass probation, we're gonna
Right.
fight or something of that
Okay,
nature.
I just wanted to know if it was included in the report. It appears that it was, and it wasn't. If that's the case, I have no further questions. So there's other, do you have a question?
Is asking for a hearing. It sounds like the complainant is asking for a hearing, which is different than the ruling.
No, the idea is the complaint is investigated, and a determination is made, or at least a recommendation is made to us. And is there probable cause? Is there cause to conduct a hearing? They determined no. I adopted that, and so the idea is this would grant the opportunity for a hearing. That's really the issue. Is
Well,
Does he get a hearing or not?
that's his stated request here.
Right.
Your recommendation does not grant the hearing.
That's correct.
Yeah.
Correct. It confirms the OEC's finding that there is no cause.
I think
No.
there's a motion on that.
There is a motion on the floor. One moment. Did you have any other questions? No. So the way this works, there is no hearing at this point, so we can't hear it right now, unfortunately. So we do have to go pursue with the rules of order, which require us to discuss amongst ourselves and then to make a decision by voting. So is there any further discussion? All right, seeing none. Well, actually, I'm sorry. Go ahead. Yeah, let me figure out where I am. Yeah, seeing none, then. Yep, okay, cool, cool. All right, then, Commission Secretary, could you please record the votes?
Commissioner Coleman,
Aye.
Commissioner Fletcher,
Aye.
Commissioner Johnson,
Aye.
Commissioner Rodriguez Kennedy.
Aye. All right, that carries that carries unanimously. That concludes today's meeting. Thank you for attending. The next commission meeting is scheduled for March 5th, 2025. The meeting is adjourned. Thank you.
Thank you, commissioners.